That's why people on the internet get enraged, because you're like, you just screwed me. You screwed my life savings. I don't think we're going to see a ruling for a few months. I don't think it's coming at the very earliest the end of March, but I wouldn't be surprised if it was into late April, early May. I don't think it goes past June.
In today's video, attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon. Before listening to him, please ensure to smash the like button and subscribe to the channel.
I think at this point in time, the SEC should govern. If you're going to have an IPO, if you're going to have an ICO, initial coin offering, if you're going to publicly raise money and then use that money to build something out, sure, that's what the SEC should monitor, along with fraud and all of those things. But there should be some you can't take XRP. I mean, when people just look at the facts, you can't take something that was traded for 7.5 years publicly and 250 exchanges worldwide. And at least 6 jurisdictions have declared it not a security. And you allow the MoneyGram and you allow Coinbase to list it and all that. And then all of a sudden it's a security as people are walking out the door, right? And ETH isn't. But then then there's an election and you get a new president from a different party and he appoints Gensler. And now Gensler is going to go back and say that ETH is a security. I mean, we can't have financial markets where that's just the whims of these regulators. And Ellie, that's why conflicts of interest are so important, because when you don't have faith, if the government officials, whether it's a Trump appointee or a Biden appointee, if they're the ones picking the winners from the losers, then we don't have a free market. We don't have capitalism. You know what I mean? It's not. And that's the problem. The problem is, and that's why it enrages people so much, because when you do your research like an XRP holder and you look at it and you look at the MoneyGram and you looked at FinCEN audit in 2015 and the Government Accountability Office called it a decentralized payment system in 2014, for Christ's sake. Well, that's safe. And I'll buy that. I believe in it. And then some political appointee, not elected, says that's an unregistered security. It can't be like that, is all I'm getting at. And so that's why when Charlie says that, Hinman is so dear to my heart, because if we don't have faith in the market, right, then we might as well not have a market. And so when Hinman has those conflicts, and when he allows the IPO for the #1 Bitcoin and ETH mining equipment company, and he makes money off that because he's a profit-sharing partner. And then his firm is a member of the Enterprise Ethereum Alliance, which exclusively promotes Ethereum, exclusively. And then he goes back to that firm. And then he goes to A16, who helped write the speech that gave ETH a free pass. That's why people on the internet get enraged, because you're like, you just screwed me. You screwed my life savings. I did everything the right way. I did my research. I did everything. And you're going to come here and do this. And so that's why people's passion gets so upset. And people got to understand, a regular guy, who has 150 grand in a retirement account in the XRP, whether that's a good decision or not, it shouldn't be based on some person walking out the door saying, oh, it's a security or it's not a security. And then the next guy doesn't have any guidance. And so Congress has just got to do their job. I'm sorry. I just wanted to make people understand, and what I would say to Charlie, I wish he was still on, to simply understand that's why it's so dear when he said, close to me and something important to me, is because do I think Bill Hinman would go to jail?
Donna.
I've never said that. Listen, the only thing I was saying is that it doesn't mean that I think that Bill Hinman would go to jail for this violation, but it means that he should be it should be investigated, and he should be held accountable for blatantly violating the statute. And that's all, because if you don't hold him responsible in this kind of scenario, then the next person does it, and the next person does it. And that's the problem. And that's why, hopefully there will be. Now, but Charlie may be right, because there's other people that feel like him, that nothing's going to be done, that, whether this is worse than it's been in the past, it is what it is. And maybe nothing will get done. I don't know, but we're going to continue fighting for it and making noise about it. And like I said, a lot of people wanted me to challenge, Charlie. And I said, listen, Charlie and I can disagree all we want and still be civil about it. But I'll challenge Bill Hinman. How about he gets on this Twitter live with me? Why don't you reach out and say, hey, John Deaton has challenged your ethics, brother. John Deaton has said that you violated the criminal conflicts law, right? You're not on trial. Come up here, defend yourself. Sue John Deaton, who said that you violated the law. Do something about it, right? But, a lot of things, because Hinman's conflicts are so blatantly in violation, a lot of people forget about Jay. I mean, Jay said that he would recuse himself from voting if it involved an enforcement action against one of Sullivan and Cromwell's clients. He said that under oath to Elizabeth Warren. And he didn't. What happened is Sullivan and Cromwell represented Consensus and Joe Lubin. And so what he did do is he voted for an enforcement action against one of his firm's clients' biggest clients. And to me, that's the functional equivalent of doing the same thing. Like, you got to recuse yourself, because if you vote for and it benefits your client, that's the functional equivalent of voting no to stop your client from being prosecuted. And then of course, Jay went to One River, which is a $1 billion fund on Bitcoin and Ethereum. And what was the speech about? How Bitcoin and Ethereum are not a security. And so I got to tell you, I've said this before, until we get term limits in this country, and also we have a 3-year bar. If you work at the SEC, you don't get to go work for the companies that you were just regulating. And if you work at the FDA, you don't get to go to work for Pfizer in the next year. Like, if you work at the CFTC, you don't get to do the same kind of thing. And so it's because of that revolving door that's desensitized people like Charlie, because he's probably, in his honest heart, he's probably seen a lot worse than what Bill Hinman's done, right? And so that desensitizes a person. It's not that big of a deal. And it's why we have to hold them accountable when you can prove it. And we can prove that Hinman violated the law. I can't prove that Jay Clayton, I can prove that he had a conflict of interest and it looked bad, but you can't prove a criminal violation. With Hinman, you can prove a criminal violation. The SEC has asked that the Hinman emails and the 58 drafts of the speech and the email comments about the speech from people like the director of trading and markets, or for Valerie S., or for anyone else, that all of that be sealed and not released to the public. And of course, Ripple objects. And the law is this: if the judge is going to rely on any of those emails for any purpose, she's going to order that they could be redacted, reasonable redactions, but unsealed and made to the public. If she decides that she's not relying on those emails for anything, then it's not a judicial document and she can seal it. So I would say that I believe that they're going to become public, but because I believe that the judge is going to rely on them for some purpose. It could be for the fair notice defense. It could be for, any kind of, factual issue or whatever. And so because of that, I lean toward they're going to be produced and publicly.
Do you think we'll see them before we get a ruling, or do you think we'll get a ruling and then we'll see?
I'm going to predict that we see them first, even though some others disagree with me, and I'm just guessing. So anybody's guess is as good as mine. But I believe that I don't think we're going to see a ruling, for a few months. I don't think it's coming. I said
I think Brad said May, didn't he? Brad Garlinghouse.
Yeah, I said at the very latest, the end of, at the very earliest, the end of March. But I wouldn't be surprised if it was into late April, early May. You know what I mean? I don't think it goes past June, but we could be in May. But there's also, the judge could decide that I'm just going to release it all together because of the drama that maybe releasing the emails is going to cause. So she wants everything dumped on the public at the same time. Maybe she does that, but I think that if I'm a judge and I got all these things, a lot of times I've looked at her previous rulings. She seems to get it off her plate and then move on to the next one. So we'll see. I could be wrong though. Just think of this, and I know. Can you name another case where at the time it was lower? So at the time, 12,600 individual investors and holders of an asset went to a court and said, "Sue me too." It's never been done in the history. So when XRP holders were so upset and felt so strong, they're saying, you know what? You might as well name me a defendant because you basically have seized my asset from me. You're calling what I own, even though I never heard of Ripple at the time, somebody, an unregistered security. So I might as well be in the case too. Go ahead, put my name down there too. And that's just never happened. It's the only time that's ever happened is if the SEC had sued a husband and they were seizing the property, and the wife comes in and says, "Hey, 50% of that's mine. I want to be a defendant too to protect my property." Other than a family situation, it's never been done. And so, yes, this is a huge deal. And a lot of people, I put out a thread that said, I don't believe we're getting regulated. Actually, you had Charles H. Addressed it as well. I think where I said that I don't see regulation being passed into law from Congress and signed by the president until 2025. All that happens, Ellie, is one party gets in power, they investigate the last 4 years of the previous party, and then that party becomes in power, and then they investigate the other party, and they can't agree on anything. So just what are the chances that the U.S. the Congress, the representative, the House is going to pass a bill that the Senate agrees to and passes a bill and that Biden signs? What are the chances of that happening? Are the Democrats like Elizabeth Warren going to agree that the CFTC should be in charge, or the SEC? Well, if she believes it's the SEC, then Warren, Davidson, Tom Emmer, and them, they're never going to agree with that. And so I hate to be a pessimist, but I just don't see it happening. And that's why these judicial cases, the Ripple ruling, even the library secondary ruling, right? Everything that's happening in court, we have to fight for it to try to get as favorable a ruling for the market as we can. And so, unfortunately, I think there's more to the drop. I said, I just think that we're going to see more enforcement actions from the SEC.